the hearsay approach.
You mean you'd like to
May I
approach?
approach you?
Yeah. You know what, we're going to take a recess. During the recess, you're admonished not to talk or converse among yourselves with anyone else on any subject connected to this trial, or read, watch, or listen to any report or commentary on the trial of any person connected to this trial by any need of information, including without limitation to newspapers, television, the internet, and radio, or form or express any opinion on any subject connected with the trial until the case is found and submitted to you. If you would please be out front in 10 minutes. Thank you.
All right, so the excellent hearing.
All right, we're outside the presence of the jury. Detective Martinez was just answering a question. You can have a seat, sir. So Detective Martinez was just answering a question that was asked by the defendant. The defendant's question was, what was the laundry list of things that the victim told you occurred? Your objection is what, sir?
He's talking about something that isn't even in the police report, slipping something in somebody's drink.
Was that in her voluntary statement?
No, no, it's nowhere. It's nowhere in here. He's just bringing it up. Stuff that's not even in the statement.
Am I correct in your question was what was the laundry list of things the victim told you that occurred?
Yes, the alleged victim.
Yes.
What was the laundry list of the things the alleged victim told you? Not something you're making up and putting in.
Thank you, Detective Martinez. Can you explain for the court the questioning when you spoke with Vanessa, was that done purely on tape? Explain to me how that was done.
That piece of information, Your Honor, is in her statement, because she recalls the incident between her and Adriano Walker at his residence where he attempts to have them shower. So that information should be in the transcription, and it's not verbatim, but that's what I'm recalling from the interview with her.
About which part did you object on? There was alcohol and
He's talking about his alcohol, there's something put in somebody's drink.
that she believes something had been taken to her
Yeah,
drink?
Where do you get that from? I done read this 100 times.
Hold on.
Yeah, funny.
I remember the alcohol, Your Honor, I'm just trying to find it for you just a minute. He did ask a question, what was the laundry list? I don't know. Every time he gets an answer, he doesn't.
So, yeah, you open the door to the laundry list. Now, if she didn't say that she thought somebody slipped something into her drink, then I agree, and I'll advise the jury that they can't consider that.
I think we should have a mistrial. That comes in the evidence that he already polluted the jury with this statement that's nowhere in here. It's hard just to tell a jury to forget what they just heard when an officer just talks about pills and stuff, drinks and stuff being put in somebody's drink.
I don't see that in Vanessa's statement. I'm going to look at Adrian's really quick, if the court can give me a moment.
It might be in her statement.
Do you remember seeing it in her statement?
It was a reference to, I put something in her drink.
Okay.
Adrian's statement, but it was not in Vanessa's, and that's what we're on. So he just jumped a witness that's not even testified, jump over to her when we're clearly on Vanessa. I asked this court to call this mistrial. He has polluted the jury with that. One guy on his way out gave me an evil face, like, he didn't hear this before.
Can I look at my statement, Your Honor?
Your statement?
Or the statement with Vanessa Robinson?
Yes.
Here, I'll give you a copy. You can have mine.
Marshall O'Kelly, could you please approach the witness with the copy of the?
Thank you, Your Honor. Thank you.
I have
Thank
it.
you, officer.
Okay.
There you go.
Clean copies. This is not small, Your Honor. This is humongous.
Well, Adrian's gonna be here, so.
Well, she's not here yet, and she ain't testified. Well, she's just,
Okay, I found it, Your Honor.
page what?
It's page 17, last paragraph.
Can you read it, please?
So no, but one time my friend went over there with me, and we were drinking alcohol, and he put something in her drink, and I knew about it. And before that, he made us change into robes.
No, that wasn't testified to.
Page 17.
Yeah, I'm looking at it.
You asked him for a laundry list of the things that she gave.
That she said was done to her. That's what I said. Laundry list of things that was done to her. That's not something that was done to her. She's talking about her friend. And he put something in her drink. And he put something in her drink would not be referring to Vanessa Robinson. Putting something in her drink is referring to Adrian Walker. I asked that this court call, this is a mistrial.
Because he answered the question that you specifically
No,
asked.
Your Honor, when I asked him to go down a laundry list of things that was done to Vanessa Robinson in his statement, it's clear that Adriana Walker and Vanessa Robinson is two different people. So he's putting things in Adrian Walker's that hasn't testified, putting things in her testimony. I could see if she had been on the stand, Adrian Walker had been on the stand already, and then he wants to bring that in, testify against that. But when we're on Vanessa Robinson and the laundry list of things that she said I did to her, this is not things he said that I did to her. This is things that he's pointing out is done to Vanessa Robinson. I mean, Adrian Walker.
He asked the question, and I understand he doesn't like the response, but in describing what happened to her, she's describing the circumstance of that whole day and that whole encounter. So that is describing what happened to her. She was asked to put a robe on, her friend was with her, there was alcohol, she thought there was something in her friend's drink. That is describing her personal experience, and he asked the question. You know what, Mr. Davis, I haven't interrupted you once.
I didn't interrupt.
I know, but your comments and your constant giggling and laughing, I've told you, if this behavior continues, I will appoint an attorney for you. Because you are allowed to represent yourself if you can conduct yourself the way an attorney would conduct yourself. If you can't, then you sit down and you get an attorney. That's your second warning. Well, really, I mean, honestly, it's like your 20th, but that's your second formal admonishment where I've had to tell you, I will appoint an attorney. Go ahead, Ms. Collins.
He opened the door, he asked the detective what Vanessa told him happened to her. Just because somebody else was there and something happened to both of them doesn't mean it was non-responsive. So, I mean, he opened the door.
All right, so I do find that you asked the question, did she provide you a laundry list of things? What were those things? I do agree that she was saying that she thought that the defendant put something in Adriana's, or Adrian, whatever her specific name is, drink while the two of them were there and that he had provided them alcohol. I don't believe that that raises to the level of a mistrial. If you'd like me to give the jury a limiting instruction, I'm happy to do that. But you have asked for a laundry list, the laundry list of things that this victim told him happened. And so that's what he's answering right now. If you would like me to do a limiting instruction in regards there to disregard the statement that he had provided, she believed you had put something in her drink, I'm happy to do that.
Your Honor, this is an uncharged bad act.
That's why you don't ask open-ended questions like that.
This is an uncharged bad act that he just put in. He just tainted the jury.
Time out. You've read this statement, correct? Yes or no? Have you
Yes.
read, you know everything that she said that you did in there, right?
No, I didn't, I misread, she didn't see that, I didn't see that
Okay,
either.
but did you know
I
in
just
there?
read it.
Did you know in there that she had said that you had provided them alcohol, or that you
No,
had
I
them
didn't know.
alcohol? You didn't know any of that was in
No,
there,
I
even though
didn't.
you have line-cited every single page of that document. I can see the highlights, I can see everything.
It's not highlighted, Your Honor.
Your
don't see
your
it?
statement isn't highlighted.
No, you wanna see, I'll show it to you, where's my page? It's not highlighted, I would've highlighted something like that. Here we go. Your
So-
Honor,
Are you withdrawing the question then?
no, I'm not. Your Honor, the question was,
Sir, I just need you to follow my directions and answer my questions. Are you withdrawing the question?
no, Your Honor.
Okay, so you'd like him to continue to answer that question?
Yes, Your Honor.
Okay. That's where we're at then.
So, Your Honor, I'm saying that the question I asked was pertaining to Vanessa. I told him
And
to say Vanessa
I understand
Robinson.
that. And now he will
He-
respond to Vanessa. I understand everything that you're saying. Your motion for a mistrial is denied. If you would like a limiting instruction telling them to disregard that statement, I am happy to provide that.
Okay. I'll take a limited instruction, you can tell me.
Okay. I'd like to take this time to remind you, sir, that I understand that you are representing yourself. This trial, we are in the second week of trial and we are literally in 1.5 witnesses. We told this jury we would be done by Wednesday. They are getting increasingly agitated. You may ask a question once, and once it is answered, you will move on. This is the last time I'm going to admonish you outside of the jury. If it continues to go on, I'm just going to politely remind you, this has been asked and answered, and it's time to move on. Do you understand?
Yes, Your Honor.
Also, I imagine that at some point, Ms. Collins may have redirect. Whatever she gets into on redirect, you may then go into recross, but we will not be hitting up new areas.
Right.
So obviously, Ms. Collins, it's the same admonishment for you. Whatever he hit on cross, you may go into on redirect. If you have anything on redirect, but I would just want to remind, whether it's redirect or recross, we're staying within the confines of what the previous person just asked. Is there any questions about that process?
No, Your Honor, but could I, for the laundry list, could you just tell what was done to Vanessa? Or she's told him, not going into the story, his story, but if he just tells, oh, he touched me, oh, he gave her a blowjob, oh, he rubbed her thigh, if he could just tell those points.
You don't get to tell a witness how to answer a question. You asked for a laundry list, and now he's giving you the laundry list.
Well, he's adding his own little twist to it, because he's not giving up laundry list for Vanessa, he's giving it for Adriana, huh?
Okay, so my staff needs a break, so we're gonna take a break now, and then we're gonna get this jury back in here. How much longer do you have with this witness?
2 more hours.
Okay, just so you know, if it's been asked already, you will be asked to move on.
2 more hours.
We'll see about that.
If I might, I'm trying to organize my schedule for the remaining week. Cleveland on Thursday for an attempted murder client. I presume that this court will want to be starting as soon as possible.
Yes.
So I'll be,
Would you like me to write an email to a justice of the peace?
I don't think it's gotten to that point just yet, Your Honor. I think the parties might themselves agree to it, but yes, I might need your help with that.
Also, I've had a judge reach out to me and ask if they would like to handle my civil cases for tomorrow so we can start in the morning. I let them know that I didn't know Mr. Klaus's or Ms. Collins' schedules, and so I don't know if it would be a situation where the parties could be here.
It's kind of witness dependent. I mean, unfortunately, I had 4 people for today. I have 1 left. Their schedules for testifying, I don't know right now. I had 4 people here for today, and I sent 2 home, and then I kept 1 hoping to get her on. She's not now available till the day after tomorrow, so I have to bring the 2 back that I sent home, and I don't know that I can get them here
So if, we're to take the defendant at his word, he has 2 hours left of cross for the witness that's on the stand right now, and it's 4:15. So that would mean that if we were to start tomorrow
Well, we have,
at 9:30 with this detective, after he was done, we could go into Vanessa at 1.
That's fine with me.
Well, I have to, because these attorneys actually have other court appearances in the morning, so I have to,
could we just do 10, just so I can try to juggle a couple things?
Mr. Klaus?
I'll make whatever accommodation. I've already moved off tomorrow's hearings, Your Honor. It's just a matter of whether or not I get new dates or I have to reach out to someone else to do it. So if you want to start at 10, I'll try and make that happen, Your Honor, and I'll be here.
Okay, thank you. All right, so my staff needs a break, so we're gonna go off.
Your Honor, I'm gonna go release my witness, okay?
Please hold. We're like, is this Mr. Holmes?
After I thought about it, I told Chris, I could have done it then. I said, my friend Will.
I put on my policy because you appreciate you bring me a hope. What case you called on? And she says, talking on anything, I'm like, what case are you calling on? He said, it's Keith. Taylor! Oh, you have to be good. Yeah. Did you call me? I don't care. You guys can't. I don't care.
All right, we're on the record in C 342-946-1. All parties are present as counsel. The detective is still on the stand. I remind you that you're still under oath, sir. And it was represented to me by Mr. Davis that he would like the limited instruction that the court offered earlier. Is that still your position, Mr. Davis?
Yes, Your Honor.
All right, bring the jury in, please. not to take into consideration, the previous testimony by the detective, regarding the statement that, it was Vanessa's belief that something had been slipped into her drink. You are to disregard that statement in its entirety, please. All right. So, Mr. Davis, did you wish the detective was in the middle of his testimony. Did you wish him to proceed?
Yes, ma'am.
Okay, go ahead.
So with my interview, or during my interview with Vanessa Robinson, I believe I left off where she described being in the apartment with her friend Adriana, and Mr. Davis had instructed them to get into robes and offered, correction, instructed them to get into robes. Adriana felt uncomfortable and was wanting to leave the residence. And Ms. Robinson stated that Mr. Davis was insistent that she stay there, and both left. Ms. Robinson stated another incident, she had went over to Mr. Davis's apartment, and he had asked for oral sex, and she stated this time she gave him oral sex for about 10 minutes, and stated that she stopped, he continued to masturbate and ejaculated onto a napkin. Ms. Robinson stated that happened inside the apartment in the same living room of Mr. Davis's residence. Vanessa Robinson stated that she recalled another incident with another female juvenile identified as, or she called her China, and she stated that Mr. Davis offered them both $100 to shower together, and both did in the presence of Mr. Davis, and he sat there and watched them masturbated and ejaculated onto a napkin as they were in the shower. Miss Robinson stated that the last incident between them would have been, or those incidents, she stated that was probably around the fall or summer of 2014, and stated the last incident would have been a few days or a couple days prior to her being booked at Clark County Juvenile Hall. She stated she was booked in June 17, and stated a few days prior to that she had the last incident with Mr. Davis. And she stated she had gone over there and they were talking about, or she was talking about a lip piercing or something, and she advised him she couldn't really stay because she had an ankle bracelet at the time, and she stated Mr. Davis insisted and wanted oral sex, so she gave him oral sex for about 5 minutes. Vanessa Robinson stated that she had given him oral sex approximately 10 times, and stated that she also masturbated him on, she believes, about 3 occasions, which that information wasn't detailed in her interview. Vanessa Robinson stated that they would communicate over Facebook, and he would ask her to come over and clean, and she knew that was her moment to come over to come see him. And that's my recollection of the statement given to me by Vanessa Robinson.
So, Vanessa Robinson never told you she was touched, her breast was touched?
No, sir.
She never told you her vagina was touched?
No, sir.
Vanessa Robinson, would you say, is she a teenage prostitute?
Objection.
Sustained.
When you, officer, when you have a alleged victim like this, do you bother to look into their background?
I do look into everybody's background.
So you look into Vanessa Robinson's background.
It's very difficult to look into a background for a juvenile, because it's not information that's just in our database.
So you're telling me you can't get, as a police officer, you can't get juvenile records when you've got a juvenile, you can't get her records?
In this case you're talking about,
Not this case, any case.
I can get juvenile records. I can get records for any subject
Right.
involved.
Yes, I understand that. So why don't you get Vanessa's records, juvenile records, and take a look at them?
Like I said, sir, I believe I looked at her, some of the database we have, but her history has no relevance to the alleged crime. I have to be neutral with dealing with any subjects,
So
regardless of history.
you give the same merit, basically, to a person that's been in trouble to a person that hasn't been in trouble. It's the same to you.
It's just documentation that I'm looking at, sir.
So it doesn't matter if they're burglar, assault, gang affiliation, that don't bother you.
That's correct.
So the ability for a person to lie or deceive does not come into your judgment.
Objection, argumentative.
I don't understand the question.
So a person's background and ability to lie or steal, or say somebody's, hypothetically speaking, somebody got a bunch of robberies, somebody got a bunch of assaults, somebody got a bunch of thefts.
I'm going to object to the compound hypothetical.
Sustained.
You give the same merit to a kid that's going to school, doing his homework, or you give this different merit, or you just say one is a straight A student and one's a dropout that gets in trouble. Which one would you believe?
Not a matter of believing in my position, sir. It's a matter of just collecting the information provided to me, and for me to take the investigative steps to corroborate or not corroborate what's given to me.
So you would go to a crime scene, investigate. You wouldn't investigate on hearsay.
Objection, compound, is that a statement?
Well,
Sustained as to compound.
so would you prosecute somebody on, would you charge someone with just hearsay evidence, or would you like physical evidence?
Objection, it's not within his purview to speculate on what may or may not be charged by the district attorney.
I'm not talking about the district attorney, I'm talking about you filing the plea.
So you're asking him whether,
Yeah.
in regards to the charges he submits to the district
Right.
attorney's office? Okay,
Mhm.
go ahead.
So would you charge a person with just saying, opposed to having evidence yourself?
To answer your question, with these type of investigations, when I say these, I'm talking about sexual assaults, sometimes we do have physical evidence, sometimes, say most of the time we don't. So every case is different. So I have investigated cases where I don't have physical evidence, but I do have statements from victims, witnesses, and the person accused of this. And sometimes I do, but every case varies.
Would you ever consider giving your alleged victim a lie detector test?
We don't give victims, specifically juveniles, lie detector tests.
Why wouldn't you want to know the truth?
It's policy and procedures for our police department, sir.
Do you interview most of your juvenile defendants while they're in custody?
Defendants, sir?
Your juvenile victims when they're in custody?
I have, yes.
So you go find somebody that's in custody and you try to get them to confess to something? Is that what you're saying?
Sir, I don't find anyone. In this case specifically, we were called by personnel from the Clark County Juvenile Hall to respond to a sexual abuse allegations.
Do you say, hypothetically speaking, if somebody confessed to prostitution to you, basically teenage prostitution, would you charge that person?
Objection, speculation, and hypothetical.
Sustained in reverse to relevance as well as speculation.
I'm trying to find out why. If somebody said they
I
committed...
understand what you're doing, the objection was sustained, move on.
Do you, Officer Martinez, pick and choose who you decide to charge with a crime?
I'm sorry, pick and
Is it your
choose.
choice of who you want to get your police report on and send it to the DA? You choose that. You make that decision, right?
That's correct.
And you make that decision based on evidence. Am I correct?
That's correct.
So basically your evidence was you had a lead with a 562 number. Am I correct?
It was one of many leads, sir.
You said that was your lead.
This has been addressed, asked and answered, move on please.
Did you get the defendant DNA?
I did not, sir.
You didn't ask the jail to get the DNA?
Not for this case. I did not request the defendant's DNA, sir.
So who requested my DNA if it wasn't you? Would you know? Or
Based on my experience and knowledge, if any person commits a felony crime and is processed at our jails, a DNA is taken for those purposes of their procedures, not to do with my case. In this specific case, I did not request DNA from Mr. Davis.
why not?
In sexual assault investigations, the time frame that we normally obtain DNA from a victim would be anywhere from 3 to 5 days. The allegation was said to have occurred well over a month for the last incident she described. It's not common practice for us to just obtain people's DNA in every case just because. We'd have to have a reason as to why a DNA would be collected, and if so, it would have to be compared to any medical examinations or clothing that, in this case, the victim may have worn.
Officer Martinez, I'm going to kind of end this on this question. What actually did you do in this investigation? Did you do any work?
There was multiple interviews done for this investigation. A search warrant was obtained. 2 photo lineups were completed. An attempt to interview the defendant was made. And again, I think that's most of the investigative steps that it takes.
Getting back to your two search warrants were written search warrants to Facebook, am I correct?
There's only one search warrant to Facebook, sir.
What was your other search warrant?
I believe I just said one search
No, you
warrant.
said two search warrants.
If I did say that in the previous statement, I stand correct. It's only one search warrant, as I said previously, for all 3 usernames.
Okay, so
I believe I said 2 photo lineups, sir.
two photos. And you did that, or I thought they did it at Caliente? I thought they did it for you.
One was completed at Caliente with my instructions, and the other one was completed by myself.
That don't seem like too much work. Okay. That's,
Is there a question, sir?
yeah, for a case of this magnitude, do you consider that a lot of work?
I can't answer that, sir, because every case varies, and I can't say it's a lot of work or it's a little work.
So, I'm gonna wrap this up. I thank you for your patience. So basically, you came back with a search warrant that was from Facebook, that was, dates were off. And you had a staff that's not trained to do lineups, do a photo lineup for you.
Objection, are we going to
That's
comment
it.
on?
No more for the witness. Thank you, Officer Martinez.
Ms. Collins, redirect.
Detective, in your job, have you collected surveillance videos from locations before?
I have.
You collected them from fast food restaurants before?
I have.
In your experience, what is the approximate longevity of the period of time they keep their surveillance videos?
Usually 30 days. Every establishment is different, but usually it's 30 days to sometimes a couple of months, 60 to 90 days.
Did you have any exact date and time to go look at Fatburger's video surveillance?
I did not.
The IP addresses that Mr. Davis repeatedly asked you about, you remember those questions?
Yes,
Every time you ping off a different Wi-Fi, you're at a different IP address, is that fair?
that's correct.
Whether you're using your phone or your iPad, you're at a different IP address.
That's correct.
So, when he's asking you those questions about couldn't you have determined the location, you would have had to track every message and try to figure out where that was sent from, correct?
That's correct.
Of everything that you reviewed in Facebook, was there any specific discussions about sex between the defendant and Vanessa Robinson?
Not specific discussions, no.
Okay. So, other than solidifying that they knew each other, what did the Facebook records tell you about what transpired in the apartment with the defendant and Vanessa?
Her frequent visits over there and the monies given to her to clean.
But not for sex.
Correct.
Mr. Davis asked you some questions about what kind of individuals you would believe or disbelieve. Do you remember those questions?
Yes, I do.
Okay. Have you ever heard the phrase victims are victims for a reason in your cases?
No, I don't
No,
specifically.
you haven't heard that, okay. Do you pick and choose your victims?
I don't.
In your mind, do you ever make the call that any specific victim deserves more or less of your attention as a detective?
I don't.
Vanessa did not get a medical exam, correct? For this case.
That's correct.
So there were no DNA samples from her body to compare to the defendant.
That's correct.
So when you talked about not making a request for any DNA comparison, it's because there's nothing to compare to in this case, correct?
That's correct.
If you would have gotten a search warrant for the defendant's residence, knowing that the allegations were oral sex where defendant ejaculated into napkins, what kind of physical evidence do you think you would have found a month later, 8 months later? What do you think you would have found?
Nothing.
Do you know anything about the admissibility of lie detector results in court?
They're not admissible.
I have nothing further, Your Honor.
Mr. Davis, anything based on those questions?
Yes, sir. So, notice you said the videos from restaurants can be held from 30 to 90 days by the restaurant. Am I correct?
Every establishment is different, so just based on my experience, every establishment has up to 30 days, up to 60, up to 90. I mean, it all depends on the establishment.
What about employees?
I'm sorry, sir, what's the question?
Did you ever consider to go interview employees of the Fat Burgers restaurant to see if these two individuals had ever walked in there together?
I did not, sir.
Why not?
The duration of the time and photographs of juveniles are not allowed. I'm not allowed to show any individual, specifically adults, photos of other juveniles. So I wouldn't be able to grab Vanessa's photo and just show it to any employee at a restaurant, which could also be a juvenile, because all the information is confidential and due to our policies and procedures with juveniles.
So, in saying that, you can show them my photo, right?
I could.
So why didn't you?
It's not, in this case, it would not be good practice to just show a photo of an individual, and I just chose not to in this case.
But you showed the photos to the people at Caliente, you mailed it to them.
My conversation with Tyler Peterson to administer this photo lineup, he was not given the information for Mr. Raymond Davis. He was neutral in the matter, and that's best practice. He didn't have any knowledge of the specific details of this case, or he did not know where Mr. Davis was positioned in the lineup, whether he was included in the lineup or not. He would have not known that information. So to answer your question, Mr. Peterson remained neutral in the photo lineup.
So, Mr. Peterson was like basically an undercover police officer or something?
He was a staff member at the Caliente Youth Facility.
So, you put this type of investigation lineup in the hands of a staff member?
This has been addressed already.
Yeah.
Move on, please.
So you brought up the fact that a lie detector is admissible in court, correct?
It's not admissible in court, no.
Correct. But can it be used by law enforcement?
It can be used as a tool for an investigation.
So why wasn't this tool used on the defendant or alleged victim?
Because in this case, if we were allowed to do that, and our procedures for any polygraph is there's a pre-interview and a post-interview, and to have a victim of a sexual abuse incident who's a juvenile re-interviewed, so to say, is not in our best practice, and we don't do that.
But to re-chant it in court is okay.
I apologize, I didn't hear the question, I'm sorry.
But it's okay if she re-chants it on court. That's okay. Recites it on court. What happened?
Her testimony,
Mm-hmm.
that's up to the court, sir.
Why didn't you interview me? Why didn't you interview me or give me a lie detector test?
This has been addressed, please move on.
I might have missed this, so I don't know if it was answered before. So I'm gonna leave it at this question. Why didn't you take me into custody?
Why didn't I take you into custody?
Yes.
The patrol officers took you into custody. They work for the Las Vegas Metropolitan Police Department as officers, and they take subjects with outstanding warrants into custody when stopped or made contact with.
So you were just gonna wait basically until I got picked up?
In most cases, through my experience, that's frequently what happens, sir.
Do you agree that the passage of time hurts an investigation?
Of whose time, sir?
Anyone's time. The police time. The
Hurts.
passage of time hurt. Shortens memories, lost evidence, people forget. Do the passage of time hurt investigations?
I'm gonna go on my opinion of not, because most of the sexual abuse cases that I deal with, there is a passage of time, and it's just memory recollection, and it's not to say that the incident did not happen, so I can't make a decision on that, or I can't answer that question, because in my experience, it shouldn't affect an investigation.
So basically, if somebody got sexually assaulted yesterday, it doesn't matter, they don't report it yesterday, they can report it 3 years later. It's still the same for you.
That's correct, sir.
No further questions, Your Honor.
Anything based on this question?
I have nothing else for the detective.
All right, thank you. Ladies and gentlemen, we're going to take our afternoon recess now. It's 5 to 5. We're going to start back up tomorrow. Oh yeah, I apologize. It is your opportunity to ask any questions if you feel like you have any for this detective. Does anyone have a question for Detective Martinez? All right. Anyone else? Parties approach, please. Marshall O'Kelly. On this one, I just need a badge number or a juror number. Okay.
Can I see that? Thanks, Deanna.
You guys already see this one? Sorry. Okay. Does either party have any objection to either of these questions?
No.
All right, go ahead, guys.
Thank you, Aaron.
Okay, first question, detective. Does Facebook records show geolocations as a neighborhood, physical address, or IP address?
That's yes. The Facebook records give the IP address, which should show, which is pretty much a geolocation of where the phone is pinging from when the messages are sent.
Second question. What was the Facebook warrant's purpose, and what timeline was supported by the Facebook warrant? So first question, what was Facebook warrant's purpose?
So my purpose to get the Facebook warrant was to show the link between Vanessa Robinson and Mr. Davis, because she has stated she had first met him on Facebook and they communicated through Facebook, and they communicated, she stated she would show up because of the communication. So I wanted to show that in fact that was taking place as part of one of my investigative steps.
And then what was, sorry, I didn't see that second question, it was about the timeline. What timeline was supported by the Facebook warrant?
The records I received were from January 1st of 2015, and I believe they were to that present day that they sent me the warrant, which would have been on or around April of the same year, I requested January 1st of 2015 to April of 2016, and that was a timeline that I put in the warrant. Hopefully that helps.
Ms. Collins, any follow-up? Ms. Collins?
No,
Okay.
no, I was just thinking, sorry.
Okay, no, that's correct. Mr. Davis, any follow-up?
Yes, so, it was a great question by the jurors. So, you could have got the basically the area where it was pinging from, the Facebook. You didn't have to get the IP address, you just had to get the area.
I'm sorry?
So, the jurors asked the geographic location. You could have used that basically instead of an IP address. That would have given you a general idea of the location that the communication is happening on Facebook.
So the IP address is somewhat of the geographic location. So your IP address at home is the same for that location of your residence, or should be the same.
And the other question on that one was the Facebook warrant, which we addressed a couple times. So it was basically a warrant to receive evidence from 2015 to, what month was that? April?
April of 2016, I believe.
And any other months you would have no information on investigating on. Am I correct?
Beyond the scope, Your Honor.
Sustained. Anything in regards to those questions, specific questions?
Okay, that's I'm fine, Your Honor.
Okay. to resist or admonish not to talk or converse among yourselves with anyone else on any subject connected to this trial, or read, watch, or listen to any report or commentary on the trial of any person connected to this trial by any medium of information, including without limitation to newspapers, television, internet, and radio, or form or express any opinion on any subject connected with the trial until the case is finally submitted to you. So normally I have calendars on Tuesdays, but another judge was willing to take my civil calendar tomorrow morning so we can keep this moving, so we can get more time in the courtroom. So, if you could be here at 10:15, and we will continue with the next witness. Thank you.
All rise for the acting jury.
All right, so just for some housekeeping matters, Detective Martinez, you're free to go. Please don't discuss your testimony with any other witness involved in this case until the case is concluded.
I will not.
Thank you. All right, so just go ahead, Ms. Collins, sorry.
So based on Mr. Davis's commitment to having the detective on the stand for 2 more hours, I moved everyone, and I will do my best. I mean, if he needs to be held to the same standard the rest of us are. He can't say I'm going to be 2 hours, 3 hours, and take 15 minutes and expect that we're going to keep people here at his beck and call when I've kind of done that all week.
Right.
So, I mean, I'll do my best, but he said he was going to be 2 hours, so I pushed everyone back, and then the investigator's gone for the evening, and
Trying to line up the
I'll-
witnesses.
I'll get someone here. I don't know who it'll be.
John, I didn't want to torture the jury anymore, so I was told to speed it up, so I speeded it up. I could have kept them there another hour and a half or so. But
Let's be
in
clear.
respect to the court.
Hold on, let's be clear. I didn't tell you to speed it up.
Mhm.
What I said was that we need to focus our question on, you need to take the amount of time that you think is appropriate for your case, and I'll allow that. What we cannot do is go into areas that have already been addressed.
Right.
And we can only go into areas on cross-examination that have been addressed in direct. That was my question. I never, in any stretch of the imagination, told you to speed it up.
I agree, but, I mean, I don't want to torture a jury, I mean, I saw them standing up, getting tired, stretching, and, I mean, not all in great shape, so, I mean, my feet are killing me, so.
All right, so the other thing that I wanted to address very quickly, let's see here, just give me a second, because I've lost my train of thought. So, as I have discussed, pursuant to the statute that I had given last week, any motions filed need to be filed 10 days before trial. And I did state that I would consider any motions filed late with an affidavit explaining good cause why they were not filed. I was just going through the motions. I haven't seen any that you filed today. I haven't seen any affidavits attached to those in regards to good cause of why they have been filed late. So I will be issuing just minute orders explaining the reason why those are denied. In regards to the motion to recuse, pursuant to statute NRS 1.235, all motions to disqualify judges need to be done 20 days prior to trial. In abundance of caution, when you orally requested need to be recused, I did file an affidavit and reach out to one of the criminal judges to see if they could hear that motion. That motion was denied. Today you filed an additional one stating basically the same things, that you feel like you're being treated unfairly, that because of my previous work as a prosecutor on certain types of cases, that you feel like I can't be unfair. I addressed all of those in my affidavit that I had previously filed Basically, everything that you've brought up are the same things that you brought up already and that you could have brought up previous to the rules 20 days before trial. So, I am denying to have that motion heard or addressed because the previous ruling, I find is still appropriate. There has been no new documentation or anything that was placed in the new motion that is any different than the things that were already addressed. So, with that, I know that we told witnesses to be here at 10:15, but if possible, excuse me, the jury, if you guys could be here at 10, so that anything we need to handle is done outside the presence, because I really don't want this jury sitting for 30 minutes, 45 minutes outside, because I know that that's incredibly frustrating.
Yeah.
So, what?
I have a psychological appointment in the morning. I'm getting a second opinion on your doctor's view, already scheduled it.
Okay, so you'll need to make sure that those are done outside of court hours. You'll have to be here by 10 o'clock tomorrow,
I
because
think the appointment was at 8 o'clock in the morning.
okay, so just make sure and let them know that you need to leave to be here by 10.
What if they keep me?
You mean if they commit you?
What if they keep me? They can.
I'm sure then you'll let us know.
Well, they don't let you use the phone.
I'm sure someone will let a district court judge know when you're on trial for a sexual assault of a child where you are. But you need to be, unless you are involuntarily committed,
Okay.
you need to be here by 10 a.m.
I was used to the afternoon hours and then. Can't do that. And at what point can I bring my witnesses, because they're still staying in hotels?
And that's really up to you. I mean, as soon as the state's done with their witnesses, you get to start calling yours. So that's up to you guys.
Yeah, and I cut down my witness list because I don't want to be here for a month, because I don't want 20 witnesses testifying. So I really cut it down to accommodate the state.
Okay, well, it's,
Some people couldn't remain here, Your Honor.
okay. All right, well, we'll get to your witnesses as soon as the state's done with theirs. See everybody at 10.
Thank you. I'll cancel my appointment, so don't worry, I'll be here.
Either way, whatever